Cash at the Judge's House has now reignited the debate of the National Judicial Appointments Commission, the NJAC. Rajya Sabha Chairman Jagdeep Dhankhar met with floor leaders of the Rajya Sabha this evening to discuss issues related to the judiciary following the allegations that a large amount of cash was recovered from the residence of the Delhi High Court Judge, Justice Varma. Dhankhar has said that the matter extends beyond just judicial concerns. It impacts the sovereignty, supremacy and the relevance of Parliament. Vice President Dhankhar has highlighted the importance of upholding the legal system as the NJAC Act was passed almost unanimously by both houses, but it was struck down by the court. Earlier today, the Congress leader Pramod Tiwari sought a discussion in the Rajya Sabha regarding Justice Varma's case. Responding to this, the Rajya Sabha chairman Jagdeep Dhankhar brought up the NJAC issue once again. He questioned the Supreme Court's decision to set aside the NJAC Act, stating that there is no provision for judicial review of a constitutional amendment that's been enacted and passed by the Indian Parliament.
There is no constitutional provision of review or appeal of a constitutional amendment. If there is legislation in the country by Parliament or state, judicial review can take place. What emanated from the Indian Parliament, duly endorsed by state legislatures, sanctified by the Honorable President by appending signatures under Article 111. We are at crossroads. I strongly urge members to reflect. There can be no breach by any institution of what emanated from the Parliament, endorsed by legislatures.
So in the meeting of floor leaders that the Rajya Sabha chairperson, Mr. Dhankhar, convened earlier this evening, the entire set of leaders cutting across the political spectrum have expressed their concern about what was seen recently, the pictures of cash burning at the outhouse of Justice Varma. Everyone was concerned about the kind of allegations that have come through on the judiciary. It is understood that the government will have one-on-one meetings with various opposition party floor leaders to try and build consensus on the NJAC. Leader of the opposition in the Rajya Sabha, Mr. Kharge, along with other opposition leaders, also said that they would like to see a discussion happen inside the House so that a consensus can be built. It's understood that JP Nada, who's the leader of the House in the upper house, along with other ministers in the government, will do a consensus building exercise before the government even thinks about bringing in a bill on the lines of the NJAC. Payal Mehta is now joining us. So Payal, what is the government sort of reading right now? Yes, the pictures that we saw from Justice Varma's house allegedly are of deep concern. That issue needs to be addressed. Yet at the same time, are they thinking on the lines of bringing a bill similar to that of the NJAC?
Well, that looks like Zaka, what they're trying to do. They're trying to bring in a bill which is going to be similar to NJAC without calling it NJAC or discussing NJAC threadbare. Right now, today's meeting was extremely important in breaking that little bit of ice, because the Vice President had asked all the floor leaders to come. And while Mallikarjun Kharge spoke about the concern that he had about the cash being burnt at the judge's house, JP Nada also said that they were also appraised of the matter and they also had equal concern. So everybody was on the same page as far as that is concerned. So they've decided to take this discussion further. Consensus is the way in which they want to take this forward. And therefore, JP Nada, who's a senior leader in the BJP and also the leader of the House in the Rajya Sabha, will be leading the discussion with various political parties. Various political parties like the Congress party and the TMC, etc., wanted to have a discussion on a one-to-one basis and not a large discussion where probably somebody doesn't get a distinctive voice. So sooner than later, this meeting will be convened and the series of meetings will be convened, after which, of course, Mr. Nada will go back to the government and, in fact, tell them what his feedback really has been to take further steps. But yes, this is a concern which is being shared by all parties, irrespective of whichever side of the fence they are from.
All right, Payal, we'll leave it at that. Let's see what comes of this, whether the government actually brings in a bill similar to that of the NJAC. But let's take a look at the main differences between the current system, which has been in place for the last 50 plus years, the collegium system by which judges are appointed or removed, and what the government wanted to bring in as a reform, which is the National Judicial Appointments Commission, the NJAC. The collegium is a system that's based on 3 judges, the senior most in the Supreme Court. The NJAC is a body that was created to end the collegium system. It has representatives both from the judiciary as well as from the executive. The Supreme Court Collegium consists of the Chief Justice of India as well as the 4 senior-most judges of the Supreme Court. You have a collegium in the High Court as well, which has the Chief Justice of that particular High Court plus the 2 senior-most judges. The NJAC had 6 members, which is the CJI, who's the chairperson, the two senior-most Supreme Court judges, and then three other members, one of whom would be the Union Law Minister, and two other eminent persons, one nominated by the CJI, Prime Minister and the LOP, and the other nominated from the SC, ST, OBC minority communities. The collegium has no constitutional backing. It's based on a judicial interpretation of Articles 124 and 217 and preserving the basic structure of the Constitution. The NJAC was introduced through a constitutional amendment, Article 124A, and the NJAC Act of 2014, which was the following year struck down by a constitutional bench of the Supreme Court. The collegium recommends the names of judges who are to be elevated to the High Court or the Supreme Court to the President. The government can object, but if the collegium insists, then the government is bound by the collegium's decision. The government's role is limited in getting an inquiry conducted by the Intelligence Bureau if a person is to be elevated as a judge either in the High Court or in the Supreme Court. NJAC would recommend names to the President. Any two members out of the committee of 6 could veto a proposal which ensured consensus. The role of the executive is limited to raising objections or seeking clarifications. It cannot reject outright if the collegium insists on a particular name. On the NJAC, though, there would be significant involvement of the executive, A, via the Union Law Minister, and the other two nominated members. The fear was that they could be influenced too, to a great degree, by the executive. So then, why did, despite the fact that the NJAC Act was passed nearly unanimously in both houses of Parliament, why did the Supreme Court strike it down the very next year? The top court said it undermines the independence of the judiciary. It said it violates the basic structure of the Constitution, which was first upheld in the Keshwanand Bharati case in 1971. The court, in its order in 2015, argued that the NJAC encouraged the executive to have a role, a say in the appointment of judges. The top court further contended that independence of judiciary is non-negotiable. The court also said in its order that NJAC had no transparency in the appointment of judges. So let's try and put that to test. And given what we've seen, allegedly at the residence of Justice Varma, is the need for NJAC coming back to the fore again. Pinky Anand is senior advocate, former additional solicitor general. Your first comments on what you saw, the cash haul controversy, the cash burning there at Justice Varma's residence, his defense so far, the investigation that's been put forth by the Supreme Court. Is it commensurate? Is it in line as per expectations? Or do you feel more can and needs to be done?
See, I don't think I'm sitting here to do a mini trial. And I really don't want to comment about what I think at this point of time. It is too premature. I do think that a lot of the actions need to be questioned for the reason that you have, ultimately, this seems to be conviction without trial. At the end of the day, what happens, we don't know. That can only happen when there is either the inquiry sustains itself or some other mechanism comes into place. And I think that is the mechanism that is being proposed, that there should be an adequate mechanism to see what is going on. So to decide on the prejudge is something which I'm afraid I don't subscribe to. If indeed it is found that there is nothing wrong with what happened and the person concerned is not guilty in any fashion, then what happens? So I think I go purely for the rule of law, and we must be sure that things are the way they are expressed to be before we decide whether that is appropriate punishment or not appropriate punishment. There is no such punishment issue at this point of time, which should have happened in any case. There are steps, of course, that are considered to be taken, but really I think this whole system needs an overhaul.
But tell me, Ms. Anand, the judicial accountability debate is back in fore. We've seen, the meeting that the Vice President has had. Various political parties have expressed their opinion. There is now a concerted feeling that there needs to be reform in the appointment and the removal of judges. NJAC was a step in that direction. The court struck it down. Do you believe that this is the direction in which we should be moving, that there should be some form of a National Judicial Appointments Commission where it's not just the judiciary alone which has a say on who gets appointed as judges, but also the executive as well as other eminent persons who should have a say?
Obviously, there is high time that we consider these mechanisms. See, this is ultimately for the purity of administration. And as some of us say, sunlight is the best disinfectant. So if you have a process in place which can neutrally go into the subject and decide what is right and what is wrong, then there are no such ad hoc actions taken which are questioned in any case. And you need to come to a certainty. We need to have certainty as far as the process is concerned. We must have a process in place. It cannot be that if somebody is guilty, he goes away scot-free, or if he's not guilty and he's actually innocent, you convict him. So where do we go from there? NJAC actually was a solution which came up, and of course, it was by unanimity. It was ultimately one of the first times a constitutional amendment came up by unanimity. It was struck down by the Supreme Court. Obviously, this is a power struggle of sorts. It came up for review. I was, in fact, the amicus appointed in the review matter, in the NJAC matter. And there, certain proposals are made, some of which were taken up, some of which went into oblivion. So at the end of the day, it was even in the NJAC judgment, everybody said that there is a problem with the system. So that is why, in fact, the review or the clarification came up, but it went to nothing. So when we are at this point of time, we are struggling with, for example, the issues of appointment of seniors, having a mechanism in place to assess, to decide merit, to decide suitability, to decide eligibility. That also is in question again. We need to put institutional processes in place so that we can ensure that the process works to the advantage of everybody and not against the interest of one or two.
But ma'am, like I said, this debate that's now raging, whether the collegium system is opaque, whether it needs reform, and clearly in light of the pictures that we saw, there is this growing sort of resonance that we need to get NJC back in some form or fashion. Certainly the political class cutting across the political divide is feeling that. The question then is, can the courts continue to take refuge behind the fact that, executive should not have a say in how judges are appointed?
I cannot say at this point of time the way it will emerge out. The attempt was to make NJAC a fairly comprehensive body, well balanced, so that it actually balances all. But history has shown that the struggle on this is the power struggle between the executive and the judiciary. And ultimately, as we all know, history has shown that the judiciary has taken up onto itself to decide what to do and what not to do. It wasn't really by way of the direct constitution. It remained with the executive. So we do have to find a balance at all times with NJAC so that it works without being at least unbalanced one way or the other. Both have a role to play, there's no question about that. But the extent of role, I'm afraid, has to be really sat down and figured out.
All right. Pinky Anand, former Additional Solicitor General, thank you very much, ma'am, for joining us here on Brass Tacks.